Kirkuk district.
Yet he is a resident of Kona Mission and Lawiadu in Mbulu district. He is therefore not a resident of Bajere East village. And for the above reasons, they and the accused is hereby denied until he produces rightful data from this business.
Bosmic team's bail denied. What happened next? Hello everyone, you are most welcome to Luo Television Legal Analysis, where we examine public affairs, legal developments, and national issues through a balanced, factual, and professional lens. Our purpose is not to determine who is guilty or who is innocent. That responsibility belongs solely to the courts of law. We analyze legal principles, judicial procedures, and the possible implications of decisions already made in open court, while respecting the constitutional right of every accused person to be presumed innocent until proven guilty. Today's analysis focuses on the ongoing criminal case involving Bosmic team, who has been remanded until 21st of July 2026 after the trial. Magistrate declined to grant him bail. The complainant in the case is KD Crystal, who alleged that he suffered grievous harm during an incident said to have occurred on 3rd May 2026. It's important to emphasize that this discussion is not intended to influence the court, or should it be interpreted as expressing any opinion on whether Bosmic team is guilty or innocent. The court alone will determine the facts after hearing all the evidence. That one should be noted clearly. Why was bail denied? According to the information presented in court, the magistrate declined to grant bail with the primary reason reportedly relating to the accused's place of abode. This is an important legal requirement in Uganda's bail process that everyone must know. A court normally wants to be satisfied that an accused person has a known and verifiable residence where he can easily be traced while the criminal trial continues. The purpose is to reduce the risk that the accused may fail to attend future court proceedings. Therefore, the denial of bail should not automatically be interpreted as punishment. Rather, it means that at this stage, the court was not satisfied that the legal requirements for release had been met. We should take note of that and understand it very well. And then, did the complainant's concerns affect the bail? We saw what happened in court. During the bail hearing, the complainant reportedly raised major concerns. The first one was he expressed fear that his personal safety could be at risk if the accused were released. Secondly, he reportedly informed court that the accused had previously jammed police bond, arguing that there was a possibility he could fail to return if granted bail. That is what we have heard. Interestingly, the magistrate did not actually appear to rely directly on those arguments when delivering the ruling, but instead focused mainly on the issue of residence. Legally speaking, however, the concerns raised by the complainant are still relevant because courts are permitted to consider the protections of complainants and witnesses when deciding bail applications. We should take note of that. It is very, very, very important. Now, let us see in this direction. Will these issues affect the next bail application? We know for sure that they want bail. The simple answer is yes, but not automatically. The defense still has the right to apply for bail again. He has the right to apply for bail. However, the next application is likely to be stronger only if the issues identified by court are adequately addressed. The defense team may need to present a clearly identifiable permanent residence, credible sureties, evidence that the accused is willing to attend every court session should be there. And any explanation regarding the allegations of jumping police bond, if that issue is pursued by the prosecution, if those concerns are satisfactorily addressed, the court may reach a different conclusion. And what are the conclusions? Each bail application is decided on its own facts. That is what we need to expect in the next bail application. What about the allegation that Bosmic jammed police bond? Let me try to digest this one very well so that you try to pick up something in this. This is one issue that deserves careful legal considerations. At this stage, it remains an allegation, not real, not actually true. Allegation presented before court. It is an allegation presented before court. If the prosecution wishes to rely on it, the court would ordinarily expect evidence showing that the accused actually violated police bond condition. That evidence needs to be there. The defense equally has a right to respond and explain the circumstances. He has the right. Therefore, the court will eventually weigh both sides before attaching legal significance to that allegation. I want to be fair and balanced in this analysis. Does the complainant's fear automatically stop bail? Is so fearful? Not necessarily. A complainant's fear are important and deserve serious consideration. However, courts normally ask whether those fears can be addressed through bail condition instead of continued detention. Such condition may include: number one, no contact with the complainant. Number two, no interference with witnesses. Reporting regularly to police. Remaining at a verified residence. Number six, compliance actually with any additional court conditions. Then the other one is the objective is to balance two constitutional principles: the accused person's right to liberty before conviction, the complainant's right to safety, and the protections of the judicial process. Now, let us also check this lawyer Odongoto's proposal for mediation. We saw the defense lawyer Odongoto expressed interest in pursuing mediation between Bosmic and KD Crystal. Legally, mediation is not unusual in criminal matters where the law allows dialogue or reconciliations between parties. However, mediation does not automatically stop criminal proceedings. The criminal case belongs to the state. The criminal case belongs to the state. Even if the complainant and accused reach some understanding, the Director of Public Prosecutions and the court still retain legal authority over how the case proceeds. Therefore, mediation should not be viewed as a guarantee that charges will be withdrawn or that bail will automatically be granted. We should take note of that. Now, could mediation also influence future bail? Could it influence in any way? Possibly, but only indirectly. If mediation reduces hostility between the parties and demonstrates that there is no longer a realistic risk of interference, the court may take that into account alongside all the other relevant factors. However, mediation itself is not a substitute to meeting the legal requirements for bail. We should take note of that. Now, what should we expect on the 21st of July? What should we expect? There are three realistic possibilities. First, the defense may return with a stronger bail application after addressing the resident issue and presenting stronger sureties before court. We expect that one. And the second one, the court may again decline bail if it finds that the earlier concerns have not been adequately resolved. And the third one is, the court may grant bails with strict conditions designed to protect the complainant while ensuring that the accused attends trial. At this stage, no one can responsibly predict. Nobody can predict which outcomes the court will choose. Nobody will predict. It is the rule of the court, the task of the court to do that. Nobody can predict that. And we should take note of it clearly, that nobody can predict what will happen on the 21st. From a legal perspective, the most significant issue emerging from the first bail hearing appears to be the questions of the accused place overboard, since that is reportedly the reason relied upon by the magistrate. The complainant's concern regarding safety and alleged previous police bond violation remain important issues that may arise again if supported by evidence and argued before court of law. Ultimately, the next hearing will depend not on public opinion, but on evidence and legal submission presented before the court. As media, our responsibility is to report accurately, analyze fairly, and respect the independence of the judiciary. Equally, every accused person is presumed innocent until proven guilty, while every complainant is entitled to have their case heard fairly and without intimidation. Thank you for watching Luo Television. I am Tekwo Wilfred. Stay informed, stay balanced, and continue following Luo Television for professional, legal, and public policy analysis.